And if one of your children had a brain injury, what would you pay as a parent?
What do you mean, brain injury?
Brain injury.
What that part of that testimony? Are you mixing? We have a lot of study telling us that that so-called gateway drug does not exist. You know that.
Well, I can tell you
that very well.
Well, I can tell you, sir.
We're trying to have a rigorous study.
Yes, sir. I can tell you, sir, from my experience in dealing with many addicted people, not one heroin addict, not one cocaine addict didn't start by using marijuana.
Alcohol.
Senator Nolan, if we have time for a second round, I'm going to put you on it. But as a supplementary, Mr. Momy, in your presentation, you said that mandatory minimums do work, and you gave, for example, the drunk driving mandatory minimums, that they do work as a deterrent. We've been trying hard to get evidence, statistical evidence, studies, anything, to the effect that minimums do deter. Were you basing that on the lived experience of your members, or did you have data to back it up?
That's lived, that's experience, knowledge, the stories of police officers, frontline police officers that are providing us information that are saying, we're not seeing the repeat ones come in front of us compared to prior years.
I'm not disputing the validity of your members' experience. I was just wondering if there were some statistics.
No, it wasn't information from StatsCan or anything like that. Yes.
Thank you very much. Senator Baker, followed by Senators Wallace, Angus, and Carignan.
Yes,
Senator
thank
Baker.
you, Madam Chair, and also thank the witnesses for their presentations. Very, very interesting. The numbers of no-case seizures that you highlighted, that seems like an unusual figure that you gave. But the police lay the charge. So what you're doing is are you criticizing the police here that they don't lay the charges upon seizure?
No, and the study that I'm referring to is a study that was commissioned by the RCMP for the province of British Columbia. Mm-hmm. And no-case seizures, charges are laid by Crown in British Columbia. And federal Crown administrator advised us anecdotally, he said, the system cannot accommodate these people. And so the relationship between processing them and the deterrent factor, folks started to throw their hands up in the air, especially in the city of Vancouver and some of those larger regions, city of Surrey, just simply didn't have the resources, the people, to process them, and the evidence that's required taking and the charges. They just said, well, let's try a deterrent factor and let's just knock them over, get what we can, get the drugs out of their hands, get their equipment, get it seized, and move on, because the system was suggested it can't accommodate the volume. And we're talking 4,500, 5,000 cases coming to the attention of police in 2003.
As the police will tell you to your right, it's the police who swear out the information, and it's the police who have to sign a document laying the charge. But I understand, we all know, of course, that there is a system set up in British Columbia whereby the Crown is consulted as to the actual laying of the charge, which is quite unusual in some provinces. Well, if the system can't handle it now, how do you think the system would be able to handle matters if you have minimum sentences and everybody who's charged pleads not guilty because of the minimum sentence? I don't know if the police would like to comment on that.
I might like to comment on one aspect of it, and I'm going to refer you to dig into that report that you've received from Dr. Plekas, because you will find these cast of characters that are going through the system are multi-repeat offenders. And I'm not talking about one or two. I'm talking about dozens of times that they've been arrested and charged with the production of marijuana. And so I'm suggesting that these multiple files, once there's a deterrent factor associated with it, we're either going to take them off the street or we're going to make them take them out of business. And that would be part of the problem that we're experiencing in Surrey. I'm certainly not sure what it's like in the rest of Canada.
What I can say, Senator, is the individuals that we see often, it's a revolving door. So these individuals are reoffending. We've all heard, you've all heard, how lucrative of a business it is. And it is, in fact, that. It is a business at the mid-level, high-level sort of drug trafficking, importing. And, if the assumption is that the jails will be full of people because of these mandatory minimums, the fact of the matter is that the individuals who are charged today will be in jail for 2 and 3 years. The enforcement side of things, if that individual comes out and is charged today and comes out 2 months from now, is given 2 months, there is a high percentage of those individuals that will be charged again and again and again. And I'm sure you've heard testimony on that particular issue. So from a law enforcement perspective, we're having to do a lot more work arresting these individuals, doing undercover operations, doing wiretap operations over and over again on the same types of organizations, the same types of individuals, instead of having them in jail where they belong. So it creates for, again, I'm only speaking from a law enforcement perspective, it provides us that ability when they are in jail for whether it's 1 or 2 or 3 years minimum, to be able to work on other organized crime groups, and then we don't have to worry about those individuals recommitting and starting up their businesses again.
We all read case law here, the reported cases, and I do understand that a lot of cases are not reported that appear before the courts. But we have a general sentencing principle in Canada of similar sentences for similar offenses, for similar offenders in similar circumstances. So the law applies right across Canada under the CDSA. And I don't see those few, as you gave in your testimony, somebody commits a very serious offense and only ends up and they can be out within weeks. I don't see that in the reported case law. But let's assume that you are correct. And, of course, you're the witness, so we're not questioning your accuracy on it. And all of these cases will be not guilty because of the minimum sentence. You've already referenced how complicated some of these cases are, from a sworn information to obtain. I don't know if you've ever sworn an information to obtain. Well, you've got 50, 60 pages, and then you've got 500 sub-affiants of police officers who have to appear in front of every case, preliminary inquiry, on to the trial, pre-trial arguments, so on, that's going to tie up your officers forever, that now is substituted as a plea bargain, and somebody goes in and pleads guilty, with an understanding that here is their offense. So have you thought about that as a consequence to your police force? You people are going to need a huge increase in the numbers of personnel to manage such a bill as this, don't you think?
Well, again, it's a presumption, I think, on our part. There's a lot of other factors, I think, that we have to look at. And if you're asking me if there's going to be an excessive amount of extra work involved in putting people in jail, ultimately for, a period of time, it would only be a guess on my part, sir.